This is 240-3364 Trinity Billing LLC versus member Select Insurance.
Yes. Good afternoon, Your Honor. Clifford Neubauer on behalf of plaintiff.
Elizabeth Spears on behalf of defendant.
All right, today is the date and time that we had scheduled a motion for summary disposition that was filed by defendant pursuant to MCR 2.116C8 and C10. Are we still proceeding with the motion today?
Yes, we are, Judge.
All right, I've had a chance to review the motion and the arguments that were put forth by defendant in support of their position. Of course, I also received the response that came in from the plaintiff a few days past the deadline, but we did get a chance to get it in, and I had a chance to look it over to be prepared for today's date. Defense counsel, what, if anything else, do you want to place on the record in support of your position?
Yeah, Judge, just briefly, I wanted to point out this is a motion about efficacy and the lack of efficacy. The articles that plaintiffs relying on, I mean, at least one is funded by the shareholders of the device. So I would say that's biased. And there was a response to that article by, non-biased entities saying it's not applicable. TENS unit articles are not applicable either because this is not a TENS unit. This specific treatment plaintiff alleges is different. That's why they charge significantly more for it. It measures the skin impediments and does this mapping is what they call it to treat specific trigger points. So it's not a TENS unit. It's not that same technology. So those articles are inapplicable. And then I don't know, you didn't mention my reply, Judge, but I did attach a number of orders.
I'm sorry, I did read it.
Okay. I have a number of orders granting this motion. I have more orders since then in the Tri-County area. All circuits have granted this motion. But other than that, Judge, I have nothing else to add.
Okay, so let me just double check. I know that came in, and I remember reviewing. Yes. Oh yeah. So this was Judge Kolakowski had his 2-page order. Judge McMillan's order was really lengthy, but seemed to identify some different issues that don't seem to be at play here. But I did review everything. So what would you like to say on your client's behalf, Mr. Neubauer?
Your Honor, everything that's needs to be argued was already outlined in the brief, and I'll just rely on the response brief filed.
Okay. So as it relates to the reply brief specifically, the theme that I noticed in some of the other judges' opinions or orders that are relied upon by plaintiff seem to be tied to a different case that was in the federal court of the Eastern District of Michigan against a number of providers, and it seemed to focus on fraudulent billing practices. And like I mentioned, specifically the opinion from Judge McMillan really seemed laser focused on that issue over the actual technology here that's being disputed between the two parties in this case. So I was curious as to why I should take those opinions and apply them to the facts that are at issue and the documentary evidence that's been presented in this case.
Well, I just want to clarify, hopefully, it's the same device. All those orders are relative to the same device. So it's all the same technology. I mean, there's other providers who use it. I don't know if that's what you're referring to, but it's the same device that all the orders are saying there's no efficacy for this particular device.
So it seemed to be a little bit more focused on the providers and the billing practices and recommending unnecessary treatments and creating false records with some of those other cases, which is not what's alleged here. Here, to me, it seemed a simple issue. Is this device effective? Is the science behind what is being presented today leaving the court with the impression that there is no genuine issue of material fact regarding the effectiveness of the device? And it appears that some of these other opinions are a little bit more focused on the providers and their practices and the recommendation of using the device when it may not be necessary, not necessarily the science behind the device, which is what the court seems to see as the only issue that's presented here in this case. Am I missing something?
No, the only issue here is efficacy. There may have been, analysis of the other allegations in those suits, but they all still held there was no efficacy established. So that may be another area that was addressed, but all those orders do address efficacy as well.
Sorry.
Maybe I'm not as confident in being able to determine from the information that's been presented by both sides here that there's no genuine issue of material fact as it relates to the efficacy of this particular device. It's a motion for summary disposition that's before the court pursuant to C8 and C10. Defendant argues that there's no genuine issue of material fact, that it is not liable for payment for treatment provided to claimant with the nervo matrix device, as the device is not fully FDA approved, has not been shown to be effective, and is therefore only experimental and non-compensable under the No Fault Act. As support for this argument that the defendant has put forth, they are relying on a number of exhibits, including an article published in 2016 summarizing a study on the efficacy of the device, a report authored by a physician for an unrelated case, deposition testimony of the former CEO of Nervo Matrix, a physician's review of deposition, testimony provided regarding the device on an unrelated case dated 2023, and a 2011 research article. Defendant further relies on the holding in Crone versus Homeowners Insurance Company, 490 Mich. 145, 2011, where the Michigan Supreme Court determined that a treatment or procedure that has been shown to be effective cannot be reasonable or necessary under the No Fault Act, and that if a medical treatment is experimental and not generally accepted within the medical community, an insured seeking reimbursement for this treatment must, at a minimum, present objective and verifiable medical evidence establishing that the treatment is effective. And that was from page 148. In response, the plaintiff argues that the circumstances presented in this case are distinguishable from those that were before the court in Crone, and that there is sufficient evidence by way of the exhibits attached to its response for this court to determine that a question of fact remains. Those exhibits include studies on the effectiveness of TENS devices, including one that evaluated the actual device that's at issue here, an article regarding the use of neurostimulation for medical treatment, and a letter regarding the substantial equivalent FDA approval for the device. In Pioneer State Mutual Insurance Company versus Dell's 301 Mich. App 368 from 2013, the Michigan Court of Appeals set forth the standard to be used in deciding a motion made pursuant to C10, which I know you're all very familiar with, in which a trial court may grant a motion for summary disposition under MCR 2.116C10 if the pleadings, affidavits, and other documentary evidence, when viewed in a light most favorable to the non-movement, show that there is no genuine issue with respect to any material fact. A genuine issue of material fact exists when the record, giving the benefit of reasonable doubt to the opposing parties, leaves open an issue upon which reasonable minds might differ. The trial court is not permitted to assess credibility, weigh the evidence, or resolve factual disputes, and if material evidence conflicts, it is not appropriate to grant a motion for summary disposition under MCR 2.116C10. That's from page 377. Reviewing the documentary evidence presented by both parties in support of their positions, this court is finding that a genuine issue of material fact remains. While defendants' exhibits include a 2016 study showing the device at issue here is no more effective than the placebo, that study acknowledged a number of limitations that may have impacted the results of the study. In contrast, plaintiff presents a study of the device from 2011, which found that treatment with the device reduced pain by 95%. Viewing these and all other exhibits in light most favorable to plaintiff as the non-moving party, It is clear to the court that a genuine issue of material fact remains that must be left for the trier of fact. In addition, while the defendant urges the court to find that the holding in Crone is applicable here, the court has not been provided with clear evidence upon which it could rely to determine that the treatment at issue here is completely experimental or that it is not in any way effective. Based on the aforementioned, defendant's motion for summary disposition pursuant to C10 is denied. So at this point, I would just need the moving party, the defendant, to submit a proposed order for signature indicating the court's decision to deny the motion for the reasons stated on the record. And then I was trying to pull up where we are at with the scheduling order in this case.
The settlement conference on the scheduling order is May 18th. I'm not sure we've actually received the date yet.
It's May 7th. So we'll just leave that date, and then this will provide an opportunity, of course, for defendant and plaintiff to consider the court's decision today if it has any bearing on those discussions for settlement. And if it doesn't, we can talk about a trial date or some other alternative dispute resolution when you come in for the settlement conference.
Sounds good. Thank you very much, Your Honor.
Thank you, Judge.
Thank you.
Have a good day.
Thank you too.
Lent Chiropractic PC versus Farm Bureau et al.
Good
Council
afternoon.
Appearance for record.
Good afternoon, everyone. John Costapang on behalf of Plaintiff Lint Chiropractic.
Good afternoon, Your Honor. Wesley Taylor, P86303 on behalf of Farm Bureau and MAIPF.
Okay, and Mr. Taylor, this is your partial motion, correct?
Correct.
Okay. You can proceed. And let me just start by saying, and hopefully you can streamline this. You know, when I get a motion and then the motion itself is like 42 paragraphs, that seems to be getting into a factual dispute. So I want you to make this as clear and concise as possible for the basis of me making legal as a matter of law, a legal finding. Because like I said, it looks just from reviewing it, I know we're talking about the TENS unit, I know you're talking about, you know, the pain levels that each of the individuals are asserting, because I know we've got Matthew Fields, Delon, and Darren. We got 3 people here. So I just need you to be as clear and concise as possible as to why the court should make a finding as a matter of law.
Well, to put it in the fewest amount of words possible, Your Honor, there is no verifiably objective evidence of efficacy concerning trigger point impedance imaging and localized intense neural stimulation therapy. Because there has been no demonstrative evidence on a subjective level with the patients themselves, because there's not a clear downward trajectory of pain improvement. And logically, there cannot be an objective finding to that fact either. And if I'm not mistaken, because I didn't see anything in my file, but it doesn't look like plaintiff filed a response.
Mr. Castain, did you file a response?
Yes, Your Honor, we did file a response. Let me get into it. I do see that it is time-stamped and for April 24th, 2025.
Yeah, he did, yeah. And I even have a hard copy, so.
But
Okay, so that being said, so in terms of that issue's out the window because he did file a response, but you
But
can
any-
go on.
But anyway, Your Honor, so the manufacturer study says there's the TPI concerning pain. There's no improvement of pain after therapy, 1 to 3 months after therapy, that corroborates the medical records from Lint Chiro. And then, yeah, there's just no objective evidence that this actually works.
Mr. Castain.
Yes, thank you, Your Honor. So plaintiff's position is that the neural matrix is not an experimental treatment. we refer to Judge McCarthy's April 14th, 2025 written opinion on the nerval matrix, where she cites two different medical articles that was presented, and that the FDA marketing approval says that the nerval matrix is similar to other other TENS units on the market, and that's exactly the treatment that the nerval matrix provides.
Why don't they use the TENS unit, regular TENS unit?
So
resolve.
in part of the studies, Your Honor, it was shown that the localized TENS treatment is more efficacious than the general TENS units. And that's exactly the treatment that the nerval matrix provides. It provides a localized directed treatment option. We also attached to our brief is an expert opinion by a medical doctor, Alan Hausnitz, and he cites to various studies on the nerval matrix and the efficacy of the nerval matrix. I don't think the defendant is relying on any expert opinion in this case. They're just citing two studies, and plaintiff has contradictory studies that proves that the TENS treatment provided by the nerval matrix is efficacious. The other position that plaintiff takes is that this, as we rely on in Oakland County, Judge Mattis said in a March 2025 written opinion that the court is unable to weigh the evidence in a C10 motion. And again, this, as far as efficacy goes, as far as the treatment, that is a determination best laid to the experts in this case. And again, plaintiff is the only party that has provided an expert report and has an expert opinion. I think that defendants need to do more than just assert that the nerval matrix is not efficacious. They need to provide evidence to support their motion. So for those reasons, we ask that the court deny the motion.
Really quick, was that expert opinion, is that expert mentioned in your witness list? Because if not, it's hearsay. Then also, Your Honor, the Medtronic opinion, Lore v. Medtronic, so that 510K pre-marketing notifications only show device equivalency. They do not show efficacy. So that's another thing I would like to point out.
And this isn't the first instance where this court has been confronted with the nerval matrix machine. There's some statements, but in terms of the efficacy, there's not been any true efficacy drawn from this. And this isn't the first time, just as Mr. Caspang has talked about what Judge McCarthy has ruled. I've ruled to the contrary, and there's other colleagues that rule to the contrary. Until we get something definitive, it's just going to be that way. And I think there's more that are ruling to the contrary as opposed to granting the use of the nerval matrix machine. So taking evidence in light most favorable to the non-moving party in the court, having previously dealt with this issue and all of the discussions, even though I've had thorough discussions on both sides from respective parties, the court finds that there is no true efficacy at this point in time for the nerval matrix machine, and the court is going to grant relief in terms of the partial summary disposition as it only relates to the services provided by the nerval matrix machine. So, Mr. Taylor, you need to present an order to the court for entry in that regard, and then you all can continue the discovery and hopefully resolve this short of seeing me back in November.
Okay, Your Honor, just for clarification, you're granting partial summary disposition.
Yes,
Okay.
yes, I'm granting partial summary disposition as it relates to the nerval matrix machine.
Okay, let's go forward with the nervo matrix then.
Yeah, and I apologize, Your Honor. I know these these have made their rounds, and I'm not
Every Friday. I get it every Friday.
I'm not entirely certain how you rule on it, Your Honor. I'd asked around.
Hey, you
and I
had to
had
go
not
for
heard.
it. Go ahead.
I did. I guess I'll hit the high notes since it sounds
Uh-huh.
like you've heard it plenty of times. The using the Crohn standard, there's no objective evidence that it's efficacious. The studies that are cited are funded by the Nervo Matrix company itself. They specifically do not address the peer-reviewed articles that state that it's no better than a placebo. In this case, I guess I would say there was an affidavit provided by Dr. Schuker. We would say it's conclusory, doesn't really go into uh, uh, the the medical journals and things like that. So ultimately, we believe it lacks scientific support. The fact that they treated for it, and even if they themselves said it was efficacious, doesn't equate to the Crohn standard. It needs to be objective, verifiable medical evidence. We don't feel that they have it.
Go ahead, Mr. Money.
Thank you, Judge. So, I mean, first, I don't think that Crohn standard should apply to this. That was a post-trial motion. There was like tons of testimony on both sides. They decided it based on that testimony. Here, we didn't do a trial. This is a pre-trial motion. So I don't think the Crohn standard is applicable just on that basis. But regardless, I mean, you have FDA clearance, which in my Exhibit A, the FDA guidelines, it specifically says, that this stuff is, if it gets FDA clearance, it's effective, and they know it's effective. I've also attached a bunch of studies that show that specifically for the conditions that these patients were treated in the plaintiffs, that it has found nervo matrix to be effective. And I also have an affidavit from the doctor that did it that says that this treatment is acceptable for this kind of diagnosis, or I'd rather say diagnoses of the plaintiffs, because there's multiple, and that, all these other interpretations of like not it being effective or efficacious are not really well understood. He said it was because it's not an actual doctor that's, making these kind of conclusions. And I know, we're lawyers, we're kind of doctors, but not that kind of doctor. So for those reasons, I'm sure you read my brief. I won't bore you with all the, reiterating all the things I said in the brief, but I ask that you deny this motion.
Okay, go ahead, Mr. Zepchinski.
Just one thing, and I've heard this argument come up quite a bit, and I think it kind of misses the mark with Crohn. Crohn was decided on a directed verdict. So it was post-trial, or it was after a trial, but there was directed verdict that was rendered in that instance, which is akin to a motion for summary disposition. It's not as if the jury decided this was a post-trial piece. It was directed verdict. So I think that piece of it, I've heard that argument come up a few different times. I don't think that's really the point of Crohn there. It is it would be okay to grant a motion for summary disposition in that context.
Okay. Well, Mr. Money, you did the work. Crohn's is distinguishable, from this case. We've got FDA approval and an expert affidavit, which leads to questions of fact as to the efficacy and the necessity of the treatment, which would require me to deny a C10 motion. So the nerval matrix motion is denied for the reasons stated on the record. The next is the shockwave treatment.
Yeah, and this, so following on the foundations for the brief are the same, but boy, is this wildly different for the extracorporeal shockwave therapy. There's only 3 specific conditions that are approved by the FDA for this treatment: tennis elbow, plantar fasciitis, and calcific tendinitis. Not at issue in any of these things. They're talking about subluxations, I think some myofascial pain. They don't have FDA approval for the extracorporeal shockwave therapy. That's not addressed in the affidavit that was submitted, I believe, I think it was Dr. Rayshuni, I believe. I think there's indications that there's FDA clearance, but again, that's specific to 3 conditions, not at issue in this one. There's references to the fact that the CPT code or HCPCS code, I guess, that was billed does have a Medicare reimbursement rate, 0101T, sure, but for those 3 FDA approved diagnoses, just because that there's a reimbursement rate doesn't mean that it's open season for everything. And I don't think the affidavit creates a genuine issue of material fact. They can't get around the fact that this is not FDA approved for the conditions that they treated it for. The study that was cited, it was a small randomized control. It was 11 folks that were in there. It's a meta-analysis for subjective pain intensity for myofascial pain only. Again, it doesn't really get around this failure to have FDA approval for these circumstances. Although this is in the same vein as the nervo matrix for the underlying basis for the motion, I think it's a wildly different circumstance that we're looking at.
This one, I have to admit, I haven't seen before. I haven't seen an issue on the shockwave treatment, but go ahead, Mr. Many.
Thank you, Judge. Again, this is, hate to reiterate, but my stance on Crohn is the same. That was post-trial. This is pre-trial. The study specifically, if you look on page 1 of 2, where it says conclusions on the study, it specifically says that extracorporeal shockwave therapy is superior to other treatments in terms of alleviating the pain intensity and pressure pain threshold of patients with myofascial pain syndrome, a diagnosis that these plaintiffs have been given. So it's not like that this doctor that wrote this affidavit is trying some, Frankenstein-like experiment with unproven technology. This is FDA cleared. It has a CPT code payable by Medicare. And I've even attached the study, a study that says it is superior, not just effective, but superior, meaning better than all other treatments in treating these diagnoses. And the same thing with the affidavit from the treating physician. He says that any sort of studies on the efficacy are just not well understood when not looked at the lens of through the lens of a medical doctor. Again, we are doctors, but of the law and not of medicine. So I ask that you grant or that you deny this motion as well, Judge.
Okay, Mr. Subchinsky, anything more?
Yeah, I don't think the affidavit addresses anything regarding the FDA clearance. If it was so well founded, I think the FDA would say differently. There's 3 specific diagnoses. They don't meet it in this case.
Okay. Well, I'm going to remain consistent here. Whether ESWT is reasonably necessary for the treatment of spinal subluxations is a question of fact for the jury to decide. Plaintiff produced an affidavit from its expert, who in fact is the prescribing doctor for the shockwave therapy. I'm denying the motions. I think it's a question of fact, not sufficient to go the granting of a C10 route. With that, we don't have a settlement conference till July 1st, so I'll see you then.
Good. Thanks, Judge.
Thank you.
I'll put in the order, obviously the denial of the motions, but then I'll also put that this motion, the other 2 motions are put over a couple of weeks. Is that fine?
So I believe we put it over till June 20th.
That's right. Okay, at 10 a.m. Okay, perfect. Thank you, Judge.
And once we get those orders entered, I just hope, you know what, I'm going to hope that it's on my clerk's radar, but if you want to say something in the order, this alleviates the need for any decision on the UM motions, you can.
Well, one step ahead of you, Judge. It's already in the proposed order that it's withdrawn, that they're withdrawn as moot or whatever. So
all right, excellent. Thank you.
Yep, no problem. Thanks, Judge.
Thank
See you, Chris.
Case number 240000647 NF.
Ms. Hassan, good morning.
Good morning, Your Honor. Attorney General Hash Hassan, PA 5117, appearing on behalf of plaintiff.
Good morning.
Good morning, Your Honor. Jordan Weiner on behalf of State Farm.
Good morning, Ms. Weiner. Mr. Weiner, they send in the big guns today?
I guess so, Judge. I don't know what happened here.
Is this one of those nervo matrix motions and Daubert and...
It is. That's exactly what this is, Your Honor. And I assume that the court is aware of the issues. And we're here on a motion for a Daubert hearing because I think that we asked for leave to file a dispositive motion and you declined to grant us that.
I remember it was a little late in the game, but so now you've built a better mousetrap, I see, with a motion for Daubert hearing.
You know, I heard you, that's what you asked us to do about 45 minutes ago, so...
Well, let me ask you something, because I think I probably got the right guy to ask here of anybody around town. Where is the Court of Appeals on nervo matrix? I mean, we see these motions week after week after week.
every judge is there any panel that's anywhere close to guidance?
I'm not,
Defense counsel just filed a response to our appeal last week. So we're expecting,
on another case?
yes, another case that we did an appeal on.
Okay, but you're not the only game in town. There's other nervo matrix out there, isn't there, Mr. Weiner? I mean,
there's like, I know of like 2 or 3 providers, a couple chiropractors and this physical therapy provider.
I've had about a dozen nervo matrix motions in the last whatever, and I know other judges are getting them. So
right.
I gotta imagine there's some panel that's close to a decision on this.
It takes time, you know, even if it's, so my guess is that even if we're still in the briefing stage or we're right at the close of the briefing stage, it's going to be another 6 months before you get oral argument. And depending on how quickly things move, sometimes it's 4 months, sometimes it's 8 months.
Let me take a wild guess. I'd be the first one around town to have done a Daubert hearing on a nervo matrix.
That is not accurate. I think we just got one ordered earlier this week in a district court case.
Oh, okay. But hasn't been held yet.
It hasn't been held yet, but it's, you know, it's the motion was, or the request for the Daubert hearing was granted.
And how do you envision this Daubert hearing rolling? Is it Dr. I forget, Dr. Super or which doctor?
This would be Dr. McGee.
McGee.
And I think he's out in Massachusetts. So.
And then aren't you going to present somebody as well?
Well, I don't know if we would need to present somebody specifically, but it would begin with Dr. McGee to try and examine his credentials and qualifications within his stated expertise, and then going into the scientific integrity of his methodologies and opinions within the Daubert framework.
Okay.
So, I mean, it's, to me, you know, I think you kind of know what's going on with the issues here. You know, you have this device that there isn't a whole lot of.
It's a fancy TENS device, isn't it? Like,
that's basically right, Your Honor. It's a really fancy TENS unit, and the efficacy of it is that it supposedly automatically finds where the pulses are supposed to go. And there's been, you know, 2 known studies. One's kind of inconclusive, and one says it's no better than placebo. And so NervoMatrix challenged that, and then there was a rebuttal, and now basically Dr. McGee says, well, I've done my own unscientific study. I went to, you know, level 1 rehab, and I talked to a handful of people, and they all said it works great. And I don't agree with the Ferrandis study, because, you know, if you discount all the people who said it didn't work, everybody else says it does work.
Well, can you address Ms. Hashem's argument about, I mean, there's some conflicting expert test. I mean, how am I calling balls and strikes on that as opposed to fact finder?
So it's not the believability. It's whether or not we hit the MRE 702 and Daubert threshold. So I'm asking and I'm imploring the court to exercise its evidentiary gatekeeping function. So we need to establish whether or not the stated expertise, which is medical efficacy of devices such as the NervoMatrix device. I don't really know what that means to begin with. So there's an affidavit by Dr. McGee says, I'm an expert in determining the medical efficacy of devices such as the NervoMatrix device. So does that mean that he is an expert in all medical efficacy for any type of durable medical equipment? Or is he just an expert in this particular device? And it's questionable because he's a critical care doctor. He's not an engineer. You know, he didn't design it. So all he does is he looks at symptomology and whether or not people say, you know, exactly what he did at level 1 rehab. I talked to people and they said they felt better. Well, that isn't necessarily inconsistent with the Ferrandis study, which said, yeah, they might have gotten better, but they didn't get any better compared to the placebo, which was just exercise, right? So then it's, now if he has these opinions, A, is he qualified to be an expert? B, if he has opinions, now we get to look into whether or not his methodologies and his opinions are reliable under the Daubert standard. Are they peer reviewed? Were they scientific? Is the sample statistically relevant? anything that kind of falls within that Daubert review. And these are things that need to be resolved before the jury can even hear the evidence, because this isn't a battle of the experts if the expert is relying on unscientific data or unscientific methodologies. Like that's the whole point of the Daubert analysis.
What weight am I to give that? Isn't there an FDA approval under, I forget, is it like
510K?
Thank you, Ms. Hutchinson.
Right. So it's not FDA approval, right? So the Nervo Matrix device was never submitted to the FDA to be approved for use for its stated purpose that's being used in this case, which is the automatic detection of where these TENS pulses are supposed to go.
So what's FDA saying that they can use it for?
They can market it as a TENS unit. So if that's the case, so if it's no different than a TENS unit, then it should be charged and collected under the No Fault Act as TENS therapy, which is about $50 instead of $6,100. So that's basically
all about the money, isn't it?
right. And I mean, like, that's basically the motivation behind it, because now we have the fee schedules in 3157 and everything's capped at, two times Medicare, or whatever it is. So the TENS therapy is capped and it's about $50 per half hour, something along those lines. But now that they say, oh, well, there could be no Medicare rate for this thing if it's not TENS. So we're saying that it's not TENS. We're saying it has this automatic diagnostic with it. And here's our expert, and that's going to get us to the $6,100 versus the $50. So the expert testimony for them is critical to get them out of the Medicare rate.
Okay, Ms. Hutchinson.
Your Honor, the Daubert standard does not require that there's scientific unanimity in order for a Daubert hearing to be held. So I don't think a Daubert motion is warranted here. As far as the FDA 510K approval goes, in my brief, I screen grabbed directly off the FDA website that the 510K already means that the FDA has already analyzed this device to be safe and effective, and that's screenshotted and highlighted in my motion and linked directly to the FDA website. So the FDA 510K doesn't mean that it's a TENS unit. The FDA said that it's substantially similar to a TENS unit, but they didn't say that it is a TENS unit, and they've already evaluated and assessed the device for efficacy and safety. So our expert would just come in and, support whatever the FDA has already backed up. There's not conflicting scientific testimony. It's just a battle of expert opinion here. So a Daubert hearing is not warranted in this case. And that's briefed, pretty comprehensively in my response. I don't think that a Daubert hearing is necessary here at all. I think it's going to be a question of fact for the jury. Absolutely. It's a difference in expert opinion. And that's not something for, I'm sorry, it's for the jury to decide, Your Honor. It's a question of fact for the jury to decide.
Thank you. Mr. Winter.
So when we talk about safe and effective isn't the standard. It's whether or not this thing is medically efficacious for the specific symptoms that are presented. And that was never part of the 510K analysis. It was so the 510K is that if a entity out there decides to come up with some piece of DME and they don't want to go through the cost of saying it's something new and novel, or they're just pulling something else to say, all right, this thing is substantially similar to something that already exists and is within the market. It doesn't need additional FDA approval because it already does the same thing that something that's already FDA approved or exists before FDA approval does. And it's being marketed for that exact same thing. So to say that it is safe and effective, that's not necessarily the standard. The standard here at least for the Daubert analysis, is Dr. McGee's opinions and methodologies that this device provides some sort of medical relief the way that they claim that it is, which is this automatic diagnostic of where the pulses are going to go. Are those scientifically reliable based on the Daubert standard? And that's also different than a jury's ability to weigh the credibility of evidence and whether there's a genuine issue of material fact. This goes to whether or not the evidence is even reliable to be considered by the jury. So it's not just enough to say, I don't need a Daubert hearing because this is a jury question. This is a question about whether the jury even gets to hear the evidence. That's the whole point of MRE 702 and Daubert.
Court's going to hold a hearing, a Daubert hearing on October 6th, the date of the trial, and I'm going to adjourn the trial until January 12th, 9 o'clock. Check your calendars for trial availability.
What was the date, Your Honor? January what?
January 12th.
And I have another trial on October 6th.
It's going to be over by January 12th.
Yeah, the Daubert hearings on October 6th.
Yeah, the Daubert hearings on October 6th, which was the date of our jury trial. In this case.
Okay.
Mr. Weiner, can you draft an order?
I will, Your Honor. Thank you very much.
Hold on, let me make sure we're all on the same page and clear before I let you go. October 6th will be a Daubert hearing. The court is adjourning the trial from October 6th until January 12th. Is that date available, Ms. Hashashian?
Your Honor, I'm pregnant and my baby's due on January 15th, so I'm trying to avoid any trials around that time.
Are you trying it or is Robert trying it?
Let me check his calendar and see. He's open that day.
Trial January 12th. The court is ordering a no more than 5-page pre-Daubert brief from each party, helping to educate the court on what to anticipate by way of the Daubert hearing. I know we've already got a little bit of it from your motion and response today. You can call it Daubert brief. I'd like to crystallize the issues by way of briefing so I don't have to spend a lot of time getting educated on some basics. That said, we're going to anticipate testimony from Dr. So-and-so from Massachusetts. He can appear via Zoom. This will be Zoom.
And I would request that if Dr. McGee has to appear via Zoom for a Daubert, his fees be paid by defense counsel or by defendant. He charges an hourly rate of, I think, around $4.75 an hour. I have to double check with him.
That's fair game. You want him here? You want him here for Daubert? He doesn't work for free, and I'm not requiring the plaintiff to pay for it.
Can I just object, just for purposes of making a record for that, Your Honor?
Well, of course you can.
So,
sure.
If this were a trial, the plaintiff would have to pay their own expert, and then they could get that reimbursed if they're successful in a motion for taxable costs or a request for costs. I'm not aware of any authority that makes any distinction between an evidentiary hearing of this sort where it's their witness and this is the testimony that they're basically trying to get the witness to, eligible for trial. So, I mean, I would assume that if they're successful, they might be able to tax costs later on down the road. That's my objection.
All right, the objection's noted, the record's made, you've asked for it. No, I don't mean that in a bad way. You asked for it at the last minute here, and the court is going to accommodate the Daubert here. I mean, had the Daubert been requested, 18 months ago, I mean, this is an issue that now on the eve of trial. I get why it's being done. You built the better mousetrap from the SD denial, but you're entitled to a Daubert, and I don't want to do it on the day of trial or during trial with a trial within the trial. So I'm trying to be efficient. But that being said, you've requested at the timing the defendant can pay his reasonable hourly fee. And I mean, I can't imagine it's going to be more than an hour on Zoom, guys, because if it's taking more than an hour, you're probably going to put me to sleep. So let's get in. Mr. Jordan can ask his questions. Jenna can ask her questions. And then I may have a few questions and then some brief argument and we're done. So if it takes more than an hour, I'd be surprised. So I'm not ordering any exorbitant amount for defendant to pay under those circumstances.
Is that for 10 o'clock, Judge?
Yeah, let's set it for 10 o'clock, guys. So I can get through my other docket.
And do you want us there in person or do you want everybody by Zoom?
We can do it by Zoom. Be efficient that way.
I don't mind coming downtown, Judge. I really
I don't want to be there in person. I'm fine with Zoom.
Well, the thing of it is I don't want to order the doctor in from Massachusetts.
It's not
So
going to fly. Yeah, it's not going to
yeah,
fly.
so if he's on Zoom and then he's on Zoom, we're in person. We might as well all be on one platform and not split. But I hear you. We order if it were more than one witness or something more complicated, we could do it in person this week.
And then if anybody intends on calling any witnesses besides Dr. McGee, can we have a witness exchange and document exchange 14 days before the hearing?
That's yeah, that's reasonable.
Calling case number 24014931 NF Multicare Health Center versus Auto Club Group Insurance Company. Counsel, will you place your appearances on the record starting in plaintiff's counsel?
Good morning, Your Honor. Nick Pandia on behalf of Plaintiff Multicare Health Center.
Good morning, Your Honor. Samantha Tronj on behalf of Defendant Auto Club.
All right. This is the date and time scheduled for a Defendant Auto Club Group Insurance Company's motion for partial summary disposition. I've had an opportunity to read the pleadings, and if you're ready to proceed, you may begin.
I'm ready to proceed, Your Honor. I am aware this court is well versed in this issue, so I'll try to keep it brief for you. But it is defendant's position that nervo matrix is not reasonably necessary or reasonable for claimant's care, recovery, or rehabilitation under 3107 because there is no objective or verifiable proof of evidence for the efficacy of nervo matrix. The Supreme Court in Crone explored experimental treatments and held that plaintiff bears the burden of providing objective and verifiable evidence of efficacy. There has been 2 studies conducted so far on nervo matrix treatment. The first was a study conducted by the shareholders of nervo matrix. It was only done with 19 participants, and it was noted that a larger randomized controlled study was still needed. Then subsequently, a second study was conducted by, I believe it was Fernandez, on the nervo matrix treatment. And they concluded that the placebo and the nervo matrix treatment, there is no difference between the 2 of them. And I know plaintiff has also provided us with additional studies. However, these studies have not provided objective and verifiable proof of efficacy of the nervo matrix treatment itself. As such, we are requesting the court grant our motion and dismiss plaintiff's nervo matrix treatment, which is billed under, I believe it's 95999 and 99199.
All right. And in response?
Your Honor, as District Counsel said, I know you're well versed on this topic, as pretty much every judge now in southeastern Michigan is. I've had this exact motion in front of you several times. And I know there's a pending litigation in the Court of Appeals. I don't have that case number in front of me, but hopefully when that gets rendered, we'll have a little bit further guidance here. But at this time, the fact of the matter is that questions of fact remain, okay? The defendant feels that the efficacy is not there, it's not reasonable, it's not necessary. I strongly feel opposite of that. And that alone is the question of fact that's needed. I have provided some verifiable, authenticated medical journals that I've used in the past, and specifically moving past that. If we're looking at the Crone case, I'm not going to, recite that till we're blue in the face, but it was a non-FDA approved procedure that was in Portugal. It's easily distinguishable from what we have here. And like I said, when I first started this argument, there are questions of fact remaining. And with that, that's enough to withstand the C10 motion. And I would respectfully request that this is denied.
Okay. You know what? You're the first attorney who's indicated to me that there is now a Court of Appeals case. I think most of the judges have been waiting for something to go to the Court of Appeals for the Court of Appeals to weigh in on this issue. Can you tell me when it was filed?
Judge, I don't have that information in front of me, but I did just have this exact motion in front of Judge Hubbard earlier this week. And if I could pull that transcript, the defense attorney gave the case number there, but I don't have that right now. I'm sorry.
Oh, okay. All right. Thank you.
I heard the same rumor. I'm not sure exactly who's filing it or where, but I've heard the same thing.
Okay. I think all of us are looking forward to the Court of Appeals weighing in on this issue because this issue is kind of circulated around in all the courts. And I know that some of the judges are ruling a certain way and the other judges are ruling a different way. So we're kind of looking forward to having the Court of Appeals weigh in on it. So is there any reply?
I'd just like to make a quick little comment. As for Crone, an experimental procedure is an experimental procedure no matter where it's conducted at. And as for the FDA approval, Respectfully, I believe that's a fallacy. The FDA approval is just a 510K pre-market approval letter, which doesn't show that it's safe and effective. It just merely allows the device to be marketed. And then I have read through the articles, and I won't bore everyone going through each article, but essentially these articles still do not analyze the nerve treatment and do not provide any reference of efficacy. So I would still ask the court to grant our motion, Your Honor.
All right. Made the record reflect, I've had an opportunity to listen to oral argument. Plaintiff is a healthcare provider, filed this action on October the 10th, 2024, seeking first-party no-fault benefits for services that were provided to claimant William Crutchers, who was allegedly injured in a motor vehicle accident. Defendant has filed this motion for partial summary disposition pursuant to MCR 2.116C10, arguing that treatment for nervo matrix is not reasonable, it's not necessary, it is experimental treatment, and plaintiff has failed to demonstrate objective and verifiable evidence as to the efficacy of the treatment. I've handled a number of these motions, and I would agree with defense counsel. I just believe that this treatment is experimental, and as such, defendant has failed to demonstrate the objective, verifiable evidence of the efficacy of this treatment. Therefore, for reasons articulated in defendant's motion as well as reply, the court is going to grant the motion for partial summary disposition, dismissing those claims for treatment with the neural matrix device. All right, and you can submit an order indicating that the motion for partial summary disposition was calling case number 24005205NF, Michigan First Rehab versus Citizens United Reciprocal Exchange. Counsel, will you place your appearances on the record starting in plaintiff's counsel?
Good afternoon, Your Honor. Ahmed Ayman on behalf of Plaintiff Michigan First Rehab.
Good afternoon, Your Honor. Abe Tabry on behalf of Defendant Cure.
All right, today is the date and time scheduled for Defendant Citizens United Reciprocal Exchange motion for partial summary disposition. I've had an opportunity to review the pleadings, and if you're ready to proceed, you may begin.
Thank you, Your Honor. This is date and time set for defendant's motion for partial summary disposition, Judge. As I'm sure you've read, the crux of the motion is regarding the TPII treatment. Plaintiff's total bill, was about $102,000. $79,300 of that was TPII related, and actually the more recent bill was $96,100. So, $79,000 out of the $96,100 was TPII related. Our position is that TPII treatment is not scientifically backed. It's not proven by any scientific evidence. There aren't any experts that verify this type of treatment. And as I'm sure you've read in our motion, Judge, TPII is typically an unacceptable procedure with no objective and verifiable evidence that of its efficacy. There's no real proof that the use of TPII would provide a better efficacy than a standard physical therapist finding trigger points. And so, it almost comes down to almost like a Daubert issue as well. There's been no, the plaintiff hasn't been able to provide any experts that verify the science or the treatment. And as Your Honor knows, in order for a medical procedure to be paid under no fault, there needs to be a reasonable necessity. So it needs to be reasonably necessary, and not having scientific efficacy kind of takes it out of that realm. In our motion, Judge, we've attached, I believe, other orders. Actually, let me look here. We've included, the, scientific evidence on our expert, Maria Fernandez. She concluded that this was basically a placebo, that nervo matrix device itself does not actually provide any supported treatment. And so our position, Judge, is that because there's really no scientific support for this. There's no empirical evidence for this kind of treatment. Again, it's not reasonably necessary and therefore would not be covered under no fault. Thank you, Judge.
All right, and in response?
And Your Honor, plaintiff is familiar on your rulings regarding this TPI motions and relies on the response brief.
All right, anything else?
No, Your Honor.
May the record reflect, I've had an opportunity to listen to oral argument. Plaintiff is a healthcare provider that filed this action on April the 9th, 2024, seeking first-party no-fault benefits from defendant Citizens United Reciprocal Exchange for services provided to Kevin Acklenberry, who was allegedly injured in a motor vehicle accident on August the 24th, 2023. Defendant Cure has filed this motion for partial summary disposition pursuant to MCR 2.116 C10, arguing that the nervo matrix treatment is not compensable under the No Fault Act as it is an experimental treatment, and plaintiff has failed to show by objective and verifiable evidence of the efficacy of the treatment. Now, plaintiff argues that the nervo matrix device was approved by the FDA in 2010, and that device is substantially equivalent to the TENS unit. Plaintiff also cites to a number of articles, and one article was speaking directly as to the TENS unit. However, this motion isn't with regards to the use of a TENS unit, it's with regards to the use of the nervo matrix or the TP2 treatment. So in viewing this motion, the court finds that the studies and articles that were cited by the plaintiff that concerned the nervo matrix were performed by shareholders of nervo matrix device, and that was Miguel Gorenberg. And his study, it indicated, although the test results were encouraging, it indicated that the major limitations on the study's design are the small sample size, the absence of a control group, and that the control group without treatment may improve low back pain as time passes. For these reasons, the study should be regarded as a pilot study only. With regards to the study by William McGee, MD, at the conclusion, it indicates additional research and larger clinical trials are recommended to further establish the device's efficacy and integration into standard therapeutic protocols for soft tissue lesions to define the full potential of the neural matrix technology. So based on that, the court finds that the use of the nervo matrix device is a experimental device, and plaintiff has failed to demonstrate by objective, verifiable evidence as to the efficacy of this treatment. So the court will grant defendant's motion for partial summary disposition. Calling case number 24007347NF, Clear Physical Therapy versus Michigan Assigned Claims Plan, and recently substituted in Citizens Insurance Company of the Midwest. Counsel, will you place your appearances on the record starting plaintiff's counsel?
Good morning, Your Honor. Ahmed Iman on behalf of Plaintiff Clear Physical Therapy.
Morning.
Good morning, Your Honor. Trevor Katona appearing on behalf of defendant Citizens.
All right. The court has scheduled this remote hearing by Zoom technology. Today, the court is hearing oral argument on defendant's motion for summary disposition. So if you're ready to proceed, I've had an opportunity to view the pleadings. If you're ready to proceed, you may begin.
Yes, Your Honor. So defendant filed this motion for summary disposition, kind of combining a few separate arguments. So I'll go, the overview is we're seeking a dismissal of services that were rendered that were never prescribed, services that where there was no prescription in effect at all, and services that were not compensable because the nervo matrix device lacks evidence of efficacy. So I imagine this court is very aware with the TPI efficacy arguments. Again, under Crone, there has to be evidence of objective and verifiable evidence of efficacy. Here, the TPI services do not have that evidence. All there's been is two studies, both of which were done at the behest of shareholders of Nervo Matrix, and one of which was a very small sample size and said, "Oh, there's some evidence of efficacy, but we have to do a bigger sample. We need more further research." And then the second study, the Friendes study, had a larger sample size that did a more thorough research and found that these services were no more effective than placebo. Outside of that, there's been arguments, some much to do about whether this was FDA approved. TPI services are not FDA approved. They have they've gone through pre-market approval notifications, but that is not the same as FDA approval. In fact, claiming that something that has gone through pre-market FDA approval, claiming that is FDA approval, is seen as mislabeling and comes with its own sanctions if a company were to do that. Other than that, there's just at this point, these TPI services, there's just no evidence that they're effective and they really do anything. So for that reason, those services should be dismissed as they lack evidence of objective and verifiable efficacy. Additionally, when physical therapy has to be rendered pursuant to a prescription from from someone who is licensed as a healthcare professional. So this is 3107BC, which says that services have to be prescribed. Physical therapy services have to be prescribed to be compensable. Here we presented a chart, which I believe is on Exhibit 4 of our exhibit, that goes through each of these, and we also attached the prescriptions, and many of the services, including all of the Nervo Matrix services, were not prescribed by a healthcare professional as required under 3107 BC. So for that reason, those services are also defendant is entitled to summary disposition of those services. And then the last sort of class of services here are services where there is a prescription, but the particular service wasn't prescribed. So these, which is also indicated in the exhibits. So it's not enough that you just have a prescription that says, oh, you have to have services. Oh, this person needs services. It has to be specific at what is being prescribed, and then only the treatment that is prescribed is compensable. Here, many of the services that were provided were not provided pursuant to a prescription, so they likewise are not compensable. And the motion also mentions that under 3173A4, a fraudulent insurance act, or if a party commits a fraudulent insurance act, then their services are barred from claims to the assigned claims plan. Here, one moment. So here, plaintiff submitted a bunch of documents in support of their claim, which falsely claimed that Ms. Harris was referred to plaintiff for TPI treatment. However, the prescriptions do not list TPI treatment. So because this is a material misstatement that is being used to support plaintiff's claims for services, this is a fraudulent insurance act, which bars plaintiff's eligibility for claims in this case. And with that, defendant requests summary disposition of plaintiff's claims.
All right. Can you tell me what physical therapy was provided without a prescription? What are the dates that you're asking the court to dismiss?
Yeah, so it's this. There's a lot of services at issue in this one. So this is where the chart on Exhibit 4 is helpful. So we list. So there's a lot of. So I could tell you the dates of service. There's a lot of them. So there's basically one on almost every day. So without a prescription altogether? No. So the ones where there's no prescription in effect at all, I see those starting on 8/14/2023. There's some of those, and then there's
I'm
more.
sorry, 8/14/2023. Okay.
Yep. And then there's prescriptions after that.
So it's just one date of service where there was no prescription?
No, and then it starts up again on January 12, 2024. There was no prescription, and that is through January 1st, 2024 through through the end of the services through July 11th, 2024. Wait, I'm sorry. And let me find the beginning and the end again. Sorry. Yeah, January 12th, 2024 through June 11th, 2024. I should have had this written down for you, Your Honor. I
June 11th, 2024. All right. So you're asking the court to dismiss those dates of service where there was no prescription for physical therapy, which would include the date of August 14, 2023, and any dates of service from January the 12th, 2024 to June 11, 2024.
That is correct.
All right. And then you're asking the court to dismiss all services where there was a prescription, but because the prescription limited the services, any services that were provided beyond what the prescription included.
That is correct.
Okay. All right. Thank you. And in response?
And Your Honor, we rely on our arguments in our response brief. I'm sure you went over it. As for the physical therapy scripts, that's for the TPI portion. As for the physical therapy scripts received specifically instructed the therapist to evaluate and treat the patient in this matter. That's in Defendant's Exhibit 2. Part of that evaluation included treatment for TPI and other various common physical therapy modalities. And we asked the court to deny defendant's motion.
Okay. Is there a reply?
Yeah, so a prescription to diagnose. So the issue with that is basically it's like having a prescription that someone else do a health insurance act. So under the health insurance code, only health professionals, doctors are able to diagnose. So a prescription to diagnose doesn't work as kind of like a golden ticket to get around the specificity required under the No Fault Act and the Health Insurance Code. Because of that, the prescriptions are only effective insofar as they are limited to the specific services that were requested for being rendering, that were requested to be rendered.
All right. May the record reflect I've had an opportunity to listen to oral argument. Plaintiff, a healthcare provider, filed this action on May the 21st, 2024, seeking first-party no-fault benefits for services rendered to Alasia Harris, who was allegedly injured in a motor vehicle accident on May 31st, 2023, from defendant MAIPF/MACP, who has now been substituted in is Citizens. Defendant MAIPF/Citizens filed this motion for summary disposition regarding no prescription for treatment pursuant to MCR 2.116C10, arguing that plaintiff is not entitled to recover for treatments that were provided, one, without a prescription, and two, that exceeded the scope of the prescription. In addition, defendant argues that the neuromatrix treatment, or TPI, is not compensable under the No Fault Act because it lacks proof of efficacy. Treatment provided was outside the scope of the prescription, and the bills were so excessive as to not be a reasonable foundation. Defendant has requested that the plaintiff's claims for PIP benefits to be dismissed altogether. In plaintiff's response, plaintiff argues that the neuromatrix, or the TPI, was approved by the FDA, that plaintiff was provided with physical therapy prescriptions to evaluate and treat the patients. Also, that the neuromatrix device is a substantial equivalent to the TENS unit, and that a study provided by William McGee, MD, indicated that the treatment was effective for neuromatrix. In the reply, defendant argues that the neuromatrix was not approved by the FDA, but only cleared by the FDA for marketing in the U.S. So after having an opportunity to listen to oral argument and review the pleadings, the court finds, one, with regards to neural matrix, the court finds that this is a experimental procedure and that the plaintiff has failed to provide the court with objective, verifiable evidence as to the efficacy of this treatment. Although plaintiff provided the study for William McGee, that study indicated that it was a pilot study and that although the outcomes were encouraging, there was a need for a wider study to be done. Plaintiff has failed to provide the court with any wider study to attest to the efficacy of the neural matrix. So the court will grant that portion of defendant's motion for summary disposition. With regards to the next issue, and that is physical therapy treatment without having a prescription. Defendant argues that there was treatment provided, or at least a bill submitted for August the 14th, 2023, January the 12th, 2024 through June 11th, 2024. Court rules and statutes require that plaintiff receive a prescription completed by a physician. Plaintiff has failed to provide the court with any other prescriptions, so that portion of defendant's motion for summary disposition is also granted, dismissing those dates of service of August the 14th, 2023 and January the 12th, 2024 through June 11th, 2024. Now, with regards to defendant's final argument, and that is that anything that is any services that are outside of the prescription should be dismissed. The court is going to deny this portion of defendant's motion for summary disposition, finding there is in fact a prescription for physical therapy, and physical therapy oftentimes includes other things other than physical manipulation and exercises. So the court finds there remains a genuine issue of material fact as to those treatments that, according to defendant, were outside the scope of the prescription. So the court will grant in part and deny in part defendant's motion for summary disposition. All right. Anything else?
Thank you, Your Honor. And just to make sure, those dates of services without prescription, that was 8/14/23, 1/12/24 through June 11, 2024. Those dates
Correct.
are out. Okay, thank you, Your Honor.
All right.
And Your Honor, would you like me to prepare an order to the effect of your ruling?
I do.
Yes, I will do that.
All right. If there's nothing else, matters adjourned. Have a good day.
Thank you, Your Honor. Take care.
Right. Calling case number 24-011-197, level 1 PT versus Auto Club. Appearances, please.
Good morning, Your Honor. To you and your staff, Pamela Campbell appearing on behalf of level 1 PT.
And good morning, Your Honor. Rick Szymanski for defendant AAA.
Go ahead, Mr. Szymanski.
Your Honor, this is our motion for partial summary disposition as to the nervo matrix TPII treatment provided. I know Your Honor's very familiar with the arguments being made.
I think I get one a week.
I was going to say, I understand you rule pretty consistently on these. So that being said, I would just rely on our briefs and I'd be happy to answer any questions you have.
Okay. Is there anything you'd like to add, Ms. Campbell?
No, Your Honor. If you have any questions for myself, I would also answer any questions as well.
No, I mean, this is the one, as I said, I get these once a week. Here, the FDA has approved the device for treatment, therefore it's not experimental. I'm denying the motion based on MCR 2.116C10 as to the efficacy of the nervo matrix treatment. The IME opinion basically just creates a question of fact, and I'm remaining consistent with all my other rulings. Do we need a next action date? Oh, no. You guys have case evaluation August 4th.
That's correct.
All right. You're good to go.
Thank you.
Thank you.
Submit an order.
Submit an order.